And you're here for, oh, could you please bring him back? All right, if you have a seat. And what's your client's name?
Jalen Ross, Judge.
All right, could I have his file, please?
Who is that? Jalen Ross. Jalen Ross.
And I see it's raining.
Oh yeah, I got poured from, I got wet from head to toe. But I was having like a lot of problems, like last night, my power kept going out. It went out like 5 times. And then like this morning, I couldn't hear you. So I apologize, but
No problem.
I did confer with the state and we would.
Well, the motions that she just filed this morning, we haven't had proper time to review them, and it'll give us at least 3 days before those motions are heard.
Oh, we can go for it. It's a motion to reconsider.
I want to just start to talk about it in chambers if that's possible.
All right, so here's the thing. Once I have motions to reconsider, I always tell people,
did I mess up the title? I'll look.
Excuse me, it went mute and I can't hear or see anybody.
yes, I know it's mute.
Oh,
Let me unmute. All right, so I'm not going to reconsider his sentence unless there's some evidence where he should have a motion for new trial.
All right,
not
that's
gonna-
correct, Judge. So I filed a motion to withdraw the plea, and I've also filed a verified motion to recuse.
All right, I don't have the motion to withdraw before me.
I have copies. So
And
that's
you
why
want to
I'm-
withdraw.
No, I'm not asking to withdraw as his lawyer. I'm asking for the court to be recused.
All right, well, what I can tell you is I'm not reconsidering any sentencing. And if you want a motion to recuse, another judge will have to hear that.
That's correct, Judge. So I'm asking that it be, and I know the state's asking for a few more days to properly.
Oh, there's
prepare.
nothing for me to do on the case once you file that. All right, thank you.
All right, thank you, Judge.
You're welcome.
Nothing?
Ross.
Can Mr. Ross be excused?
You can be excused.
Okay, thank you for your time.
All right, thank you.
Sounds good. Okay, we'll go on the record in People versus Mallerie Span. This is Crawford County case number 245348.
Okay, everybody sent this to me, starting with Chrissy, from Court with Chrissy, and Brecken and Zach over at Law Nerds Unite and the Plausible. There's a whole list. There's a whole conspiracy to bring you guys content, and this is just excruciating.
If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush appearing on behalf of Ms. Stefan.
All right, and record should reflect Ms. Stefan is present there in the courtroom in Crawford County. I'm connected by Zoom, as is Ms. Koch. Mr. Trush is live with his client at the courtroom in Crawford County. Mr. Trush, my understanding is that Ms. Stefan wishes to enter a no contest plea today. Is that correct?
I do believe that that is what we are going to do today.
Okay, can you tell me what the terms of that agreement are?
So the terms of the agreement.
Okay, I need to thank. We're gonna cut into that. I need to thank Law Nerds Unite for this. Who else? There's a whole bunch of people. Brecken's involved. KDM's involved. Who else? CC Truck. At Objective. There's a lot of people to blame for this. But here's the situation. If you go rolling into Judge Washington's room and start swearing, my people are going to find out about it. That's all there is to it. I haven't seen it. This was developing as I was putting my stream together.
The court will call the case of the state of Michigan versus Briana Likes, 25S00120.
Briana Likes.
Assistant Public Defender Davey before Ms. Likes.
Ms. Woods, can you place your appearance on the record?
Tiffany Woods for the people.
All right, thank you. So we are originally here for a pretrial in this particular case. The court passed the matter when Ms. Likes' camera was off and the court was unable to see her. In the interim time period, Ms. Likes apparently turned her light on and then put in the chat "This is bullshit. I have a different court to be at as well." So first she's cursing in the chat, and then secondly,
I don't get what Judge Washington is upset about. She's too important to be in her courtroom. I think that's pretty clear. She should feel honored that she showed up.
I have an image of her giving the middle finger to the court. And as I indicated before I recalled this case, Ms. Likes is going to be found in contempt of court regarding both of those decisions that she made this morning, and she's going to do jail time. You have a right to have a hearing on the contempt proceeding. You can request that if you so choose. Mr. Lebo, what would your client like to do?
Ms. Likes would admit to both.
Ms. Likes, is it true, ma'am, that you wrote in the chat, "This is bullshit"?
It was not supposed to go to the chat. It was supposed to have went to a family member that I was responding back to, and somehow it ended up going to the chat, and it was not supposed to have. The part where I did say that I do have another court as well, that was supposed to have gone into the chat for you guys, but the other part was not supposed to have.
Now, my question was, did you put that in the chat?
No, I did not.
All right. Then we're going to have a hearing.
Ms. Likes, are you sure you want to deny putting that in the chat?
I mean, like, what else am I supposed to do? Like, it was not supposed to have went to your guys' chat. Like, so screw it. Like, it went to your guys' chat. I understand that. Like, so what are you suggesting?
All right. All right. You're going to grammar camp. In addition to the contempt, you're going to grammar camp directly afterwards. So you've got a little jail time for contempt, and then you've got detention to serve.
I do.
Ms. Likes, would you like to have another breakout room with me?
Sure.
Possible.
I don't get your guys's. It's just your. You actually have to say the right thing before you screw it up. It's maddening.
Are we going to do a breakout room?
I was the worst in English and grammar and everything throughout school. From the beginning of time. It is a sad commentary. It is a sad, sad commentary on the state of the United States that I cannot deal with the poor English being used.
You can give them the breakout room.
I'm sorry, I was waiting for you. Judge, could you give me the exact date and time for that hearing? I'm sorry, I didn't get it written down in time.
July 17th at 11 o'clock a.m.
Thank you.
The court will recall the matter of the state of Michigan versus Briana Likes, case number 25S00120.
Tiffany Woods for the people.
Assistant Public Defender Davey Liu on behalf of Ms. Likes. Ms. Likes, please state your name, ma'am.
Briana Likes.
Thank you. What would your client like to do?
Ms. Likes, at this time, would you like to admit to the contempts of court that were discussed?
Yeah.
Thank you.
Ms. Likes, please come to the camera.
Yeah.
Please,
Can you guys hear me?
yes. Ms. Likes, is it true that you put this is bullshit in the chat?
I'm not meaning to, yes.
Is it also true that you put up a middle finger at the camera, ma'am?
Sure.
That's a yes or
Sure. You see how that's really consistent with the prior question I asked you? It's kind of like a theme. It makes it feel like the first thing was intentional. Just saying.
no, that's not a sure.
Yes.
Defendant is to complete 10 days in the Washington County Jail. When does she want to turn?
And I do apologize for doing what I did. And it won't ever happen again.
Good.
Is there anything from the people on this?
Judge, I just know that she's here for a case, a child abuse case, Judge. So I know she has a young child, I believe a 4-year-old. I just would like for the defendant. I would just like for the defendant to take a look at her
She's not
behavior.
eating. She's not going to look at her behavior. Now she's eating in court.
I have a deficiency where my sugar drops really, really low, so I have to eat something because my sugar did drop really low.
Oh, sweet Jesus. Do I have to get out my IBS clip?
And I did just take it to make sure that my sugar was low, and I do apologize for that, but I have to eat something to bring my sugar back up.
I just think she's setting a poor example for her children, and she's setting a poor example for the judge and the people as to how we're going to resolve this case. And that it doesn't look like she appears to be taking any of this seriously. In court, we all wait around for the hearings, whether the hearing is scheduled at 9 or 10 or 11. It's frustrating, but it's something that as an adult, we sit quietly, we pay attention, because that's the right thing to do when you're in court. And as a mother who's setting an example for young children, I would have liked to have not have this happen, because I think that the defendant right now is setting a very poor example for everyone, including her children, Judge.
Anything from you, Mr. Lebo?
I would just ask that the court consider an alternative sanction such as community service. This perhaps an anger management program.
Defendant is to complete 10 days in the Washington County Jail. I'm going to hold that in abeyance. Defendant can do an impulse control class.
Oh, man. Her kids were going to potentially have up to 10 days of competent supervision under the prior arrangement.
To purge her contempt and not do jail time.
Thank you, Your Honor. I'm sure Ms. Likes very much appreciates that.
Thank you. And I do apologize for me eating, but I have to bring my sugar up.
What do we do with the Regarding the pretrial,
Your Honor, we're going to set that matter for a bench trial, please.
for what trial?
A bench trial, Your Honor.
Are you sure that's what you want to do?
Could we approach for a moment?
Sure.
All right. Thank you, Zach. There may be more, and if there is, I'll break in with it. Zach's helping me out with this.
1, the assaulting a corrections officer charge would be dismissed. Count 2 would be amended from resisting and obstructing a police officer to attempted resisting and obstructing a police officer, reducing it from a 2-year offense to a 1-year offense. Count 3 would stay as charged, and count 4, the escape from lawful custody, would be dismissed.
Ms. Koch, is that a correct statement of the plea offer?
It is.
Ms. Stefan, can you hear me okay?
Yes.
Have you had an opportunity to talk to Mr. Trush about this plea agreement? Have you had a chance to talk to your lawyer about this plea agreement, Ms. Stefan?
Sort of.
Do you need more time to do that, or are you ready to proceed today?
Can I have more time to do that?
How much time do you need? Hello?
I'm not sure.
Ms. Stefan, I know this is kind of a pattern with you. You like to do this and indicate that you're going to go forward with something and then say you're not sure and you don't know.
Okay. It turns out I've already got it from Zach over at Law Nerds Unite. Big shout out to Law Nerds Unite. Let me find it. For the resolution of the kook in front of Judge Washington.
All right, we're back on the record in the Briana Likes matter. We had a chance to talk about this particular matter. I explained to the prosecutor the court's position with respect to how I view the law regarding child abuse 4th degree. The prosecutor has been fully informed on that. I am familiar with some basic outline of the allegations in this case. The court would obviously be fair with respect to this particular charge. However, I think that the prosecutor needs to speak with supervisor about the court's stance regarding the law as it comes to the child abuse 4th, and Ms. Likes needs to get her course done so she can purge her contempt. We'll put this all over to July 10th. And at that time, we'll see whether or not we need to have a waiver and whether the prosecutor would waive given the court's position regarding child abuse 4th degree. All of those are things that, because the prosecutor would have to waive to a non-jury trial as well. So those are all the things that need to be flushed out before we are in a position to move forward. And so we'll put this to July 10th at 9:00 a.m.
Thank you, Your Honor.
Ma'am, you need to contact the probation department so they can advise you of how you can get that class taken so you can purge your contempt.
Ms. Johnson already provided that information.
I did just receive that in an email from Ms. Johnson. I'm going to forward that to Ms. Likes right now.
Thank you.
Thank you.
You're welcome. We'll see you back then. Bond is continued.
Okay, and that'll be July 10th at what time?
At 9 a.m. It's on Zoom again, ma'am. Okay.
Okay, thank you.
All right. Well, there you have it. That's what's going on. I don't know what she was on about with the whole when they approached and she said, I don't know if you know how I feel about these charges or something like that. If she's got some special position about, I mean, what? Disliking child abuse? I think 100% of the population has that position. I don't know if anybody knows, because people will ask me and I don't know. I was watching that and it confused me. If someone has some idea of what Judge Washington was on about when she said that, put it in the chat so that people can see it, because I don't. Ultimately, this thing got continued. It's not clear to me whether there's any sanction on her in the meantime, or if it's all held in abeyance and then we're just gonna bring it all back up and forget about it on July 10th, probably. I don't know. But thank you everybody for getting that to me. It's still fun to see someone get that rowdy in Judge Washington's courtroom. All right, back to the regular scheduled program here.
So I'm not going to play games with you here today. I'm not going to waste my time. I'm a busy person. So if you want to enter into this plea today, we'll do it. If not, we're going to go forward with your trial on Thursday. So you need to decide that right now. What do you want to do?
I don't know.
That's not an answer. You either need to say you'd like to proceed with your trial, or you need to say you want to enter into a plea today. I don't know. It's not an acceptable answer.
Your Honor, can we have 5 minutes to talk?
Yes. We'll go off the record, and Ms. Koch, if you could just remain on the line, please. Thank you.
Oh, sweet Jesus! What? Made in September. It's been pending for 9 months. Thank you. Revoked after today's hearing. It was made in September. It's been pending for 9 months. Thank you.
Well, I want you to say that again when Ms. Stefan is there. I don't know if she heard that, so.
Okay, thank you.
Judge, I can go advise them.
Yeah, thank you.
Yep.
Ooh.
Okay, Ms. Koch, if you can.
Thank you, Brecken. It looks like she actually edited
Okay,
this
thank
for
you.
me.
Okay, Mr. Trush, how are we going to proceed?
Your Honor, I believe she intends to take that offer, but again, I'll ask the court to directly inquire of her.
Okay, Ms. Stefan, are you going to proceed with the plea today?
Yes.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Ms. Stefan, are you currently on any kind of probation or parole?
No.
You understand that by pleading no contest to attempted resisting or obstructing a police officer, the maximum penalty you could face would be up to 1 year in jail. Do you understand that?
No.
What don't you understand about that?
Can you repeat that?
Yes, the maximum possible penalty for the charge of resisting or obstructing as an attempt is up to 1 year in jail. You understand that?
Yes.
The maximum possible penalty that you can face for domestic violence as a second offense is also up to 1 year in jail. Do you understand that?
Yes.
With those maximum possible penalties in mind, what is your plea today? Are you pleading no contest to those two charges today?
Does that mean I'm pleading guilty?
Well, my understanding is the plea agreement is that you're going to plead no contest.
So Mallory, we discussed the difference between a guilty plea and a no contest plea. In a no contest plea, the judge would review the police report to form a factual basis. In a guilty plea, you would tell the judge under oath what occurred on that night that would make you think you were guilty of the offense. You understand the difference?
Yes.
So the judge is asking,
Yeah, go ahead, Mr. Church.
are you pleading no contest to the charge today?
Okay.
Okay is not an answer. Yes or no?
Oh, sweet Jesus.
Yes.
I'm sorry, what's that? Yes or no, Ms. Stefan?
I said yes, it's fine.
All right, I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and the right to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
Okay.
Again, that's not an answer. Do you understand them or not?
Most of them.
Which ones don't you understand?
Can you repeat the last couple of them, please?
I'll repeat them all for you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it.
I want a trial.
So you're not going to plead no contest today?
Is the no contest the same as pleading guilty? Or is it just
No,
taking the plea?
It's not the same, and your attorney just explained to you what the difference is.
Okay.
So are you going to move forward with this plea today or not? Ms. Stefan, are you going to go forward with this plea today or not? Yes or no? I don't care which it is. Doesn't matter to me. I just need some answers from you. That's all. One way or the other. We have a trial scheduled and ready to go on Thursday if you want to have your trial.
I'm just confused, that's all.
Okay, so I don't believe you when you say you're confused. You've had many, many months and numerous court hearings where all of this has been explained to you. I know that Mr. Trush has fully explained everything to you today as well. So I just don't believe that you're confused or you don't know what's going on. You need to make a decision now. And again, I don't care. We have your trial date all set. We're all ready to go on Thursday. More than happy to do that. But if you're going to enter a plea today, then that needs to happen right now.
Okay, fine, yes.
Okay. Do you understand all those rights that I've listed for you?
Yep.
And you understand that you're giving up and waiving all of those rights by pleading no contest? You understand that?
I can't be in here.
Do you understand that you're giving up all those rights by pleading no contest?
Yes.
Has anybody threatened you with anything to get you to plead no contest?
Ma'am, are you a whore?
You with anything to get you to plead no contest? I'm going to ask one more time, Mrs. Span, and then that's it. I'm going to end this hearing and we'll proceed on Thursday. Has anybody threatened you with anything to get you to plead no contest?
No.
Has anyone promised you anything other than what we've said here in court today?
No.
Is it your own free choice to enter this plea? Is it your own free choice to enter this plea?
Okay.
Yes, it is. Or no, it's not. Ms. Stefan, is it your own free choice to enter this plea today? Yes or no? Okay, I'm going to ask you one final time. Is it your own free choice to enter this plea? Yes or no?
Okay.
Again, okay is not an answer. Yes or no? Yes or no, Ms. Stefan?
I guess so, yeah.
Sarah, did she say, I guess so, yes?
She said, I guess so, yeah.
All right, okay,
Not yes, but guess so, yeah.
all right. Mr. Trush, have you reviewed the Crawford County Sheriff's Department report number 24120011073?
I have, Your Honor, and I went over that with Ms. Stefan before the hearing today.
All right, and Mr. Trush, would you agree that that police report and the information contained within that, specifically pages 3 of 4, well, actually, yeah, 3 of 4 and 4 of 4, that the information would provide a factual basis for finding of guilt as to the count 3 and the added count 5 of attempted resisting obstruction?
Yeah, Your Honor, Ms. Stefan has.
I know I need time to think about that, so.
Oh, she
Ms.
needs
Stefan
time.
has just indicated to me she does not want to take this plea deal.
Okay. All right. So, Ms. Stefan, we're going to proceed with your trial on Thursday. You need to be present in the courtroom by 8:30 on Thursday morning. You need to communicate with your lawyer between now and then so that Mr. Trush can be fully prepared to go forward with your case. I think we probably already covered this at a prior hearing, but Ms. Koch, you have already submitted jury instructions, is that correct?
That is correct. We are prepared. We have all of our witnesses served and ready to go. People are ready to proceed. Thank you.
All right, and Mr. Trush, have you submitted any of your proposed instructions or any objections to the prosecutors?
I believe that we did submit, I think we submitted them prior to the prior trial date, which I think got adjourned. I would indicate, I have prepared a self-defense instruction. I didn't submit it because I don't know if it will become relevant or not, and it likely will turn on if Ms. Stefan testifies and what that testimony looks like. But I prepared multiple copies of it in case it does become relevant.
Okay, all right, very good. And just for the record, because I don't know if we caught it before, but Ms. Koch, you're withdrawing the plea offer, is that correct?
I am withdrawing the plea offer today. We will proceed to trial on all of the felony charges. Thank you.
Okay, so Ms. Stefan, this is your last chance. Once we go off the record here, there will be no more plea agreements. Even if the prosecutor offered it, I wouldn't accept it after this. So, is that your decision?
Can you repeat the question, please?
Just asking for a final decision from you as to whether you want to go to trial or whether you want to accept this offer today. This is going to be your last opportunity.
Ask for a lifeline.
Okay.
I don't know what okay means. Do you want to go through with the plea or not?
I really need a few
Yes or
minutes.
no? No more minutes. You've had months and months and months to make a decision on this. Another 5 minutes isn't going to change anything.
Okay, let's,
I couldn't hear you. What?
yes,
Yes, what? You want to go forward with the plea or you want to go to trial?
Yes, with the but.
all right, it's fine.
When you say it's fine, do
I,
you mean that you want to proceed with the plea or you want to proceed with the trial?
I'll keep going with it today.
Do you want to enter into this plea agreement? Yes or no?
Yeah, yes.
All right. So again, I think we were going through the factual basis, Mr. Trush. Would you agree that the information I've identified would provide a factual basis?
I do, Your Honor.
Ms. Koch, have you reviewed that police report that I've identified for the record?
Yes.
Would you agree that it provides a factual basis? Charges?
I don't get to tell my side.
I'm sorry, Your Honor, I didn't hear that question.
That was directed at Ms. Koch. I'm just establishing whether she's satisfied with the factual basis based on the information contained in the report.
Yes, Your Honor.
Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record today?
No, Your Honor.
Mr. Trush?
No, Your Honor.
Ms. Koch, are the people satisfied that the court has complied with statute and court rule in taking in this no contest plea?
Yes, Your Honor.
Mr. Trush?
Yes, Your Honor.
Ms. Stefan, the court finds that your plea is knowing and voluntary. I'm going to mark that police report that I've identified as Court Exhibit 1 and admit that to the file as the factual basis. I've reviewed the information. I find that it does provide a factual basis to support a finding that you are guilty of each of these charges. The court will accept the no contest plea. The court will set this matter for a sentencing hearing in about 30 days. In the meantime, Ms. Stefan, you're going to meet with Mr. McFalda, I believe, today before you leave the courtroom to set up a time for a pre-sentence report. Then it's important that you stay in touch with your attorney prior to that sentencing date. You'll have an opportunity to go through the pre-sentence report with him. In light of the plea, the court will adjourn the trial set for Thursday. Ms. Koch, anything further from your side today?
No, Your Honor. We will call off our witnesses for the trial. Thank you.
Mr. Trush?
Never mind, go on.
Nothing further, Your Honor.
Okay, thank you. That's all for this hearing today. All sides are free to disconnect at this time.
Court is on the record in State of Ohio versus Marissa Muteroni. Case numbers 25 CRA 166 and 25 CRB 167. On May 28, 2025, Ms. Muteroni pled not guilty to one count of aggravated possession of drugs, a 5th-degree felony, and one count of attempted aggravated possession of drugs, a 1st-degree misdemeanor. In these cases, respectively, these cases are set for a preliminary hearing and pretrial conference today. Ms. Muteroni is present. She's accompanied by her attorney, Mafid Syed. Also present is Law Director John Lewis. Court is in receipt of a pretrial report. Mr. Lewis.
Thank you, Your Honor. The offer that's been extended to Ms. Muteroni would be to dismiss the felony charge at her cost. With that dismissal, the offer would be to plead to the attempted aggravated possession of drugs, with the State of Ohio recommending probation. Whatever fine the court would deem appropriate, along with the court costs of the case. And the State of Ohio would recommend that Ms. Muteroni remain in this court's renewal court program. Thank you.
Thank you. Mr. Syed.
Thank you, Your Honor. Your Honor, I had some extensive talks with my client, went over, the possible outcomes of today and for the future. At this time, she just told me she wants to get it done and over with. She wants to continue to be in the renewal court. She wants to graduate.
I haven't seen this yet, and nobody told me that she was represented by a munchkin.
So at this time, she's accepting the offer from the law director. All I ask is that we just be heard on the sentencing.
Okay, Ms. Muteroni, it's my understanding today that you would change your original not guilty plea and plead guilty to one count of attempted aggravated possession of drugs, a first-degree misdemeanor in 25 CRB 167. In exchange for that guilty plea, the felony drug charge would be dismissed at your cost, that being in case number 25 CRA 166. Is that what you wish to see happen today?
Yes, sir.
You understand by pleading guilty to this misdemeanor charge that you are waiving your right to a trial, which includes your right to cross-examine witnesses and to confront evidence presented against you. You'd be waiving your right to testify or not to testify without any negative connotation. You'd be waiving your right to subpoena witnesses. You'd be waiving your right to a jury trial. You'd be waiving your right to be proven guilty beyond a reasonable doubt. All of those are trial rights you'd be waiving by pleading guilty to this charge today. Is that what you wish to do?
Yes, sir.
You are represented by Mr. Syed. Have you had sufficient time to consult with him, and are you satisfied with his counsel?
Yes, sir.
Are you currently under the influence of any drugs, alcohol, or prescription medications that might affect your thinking?
No, sir.
We know you're on probation here, but
And are you willing to share with the group?
are you currently on probation, parole, community control, or post-release control with any other court?
No, sir.
Has anyone made any promises to you about what your sentence will be in order to induce you to plead guilty to this charge today?
No, sir.
And are you thinking clearly and do you understand everything that's happening?
Yes, sir.
Okay, I'm going to provide to you and to Mr. Syed your written waiver of your trial rights and right to a jury trial and acknowledgement of effective plea. If you find that document acceptable, you can sign the date at the bottom.
It's executed, Your Honor.
Thank you. Court does find that the defendant and her attorney have executed in open court the written waiver. Court does find the defendant's plea of guilty to attempted aggravated possession of drugs, a first-degree misdemeanor, to be knowing, voluntary, and intelligent. Court will accept the guilty plea to that charge, and I will therefore find her guilty of that offense. I will dismiss, pursuant to the negotiated plea, the felony charge of aggravated possession of drugs in case number 25 CRA 166 at the defendant's cost. Okay, Mr. Syed, is there anything you or your client would like to say in mitigation of sentence?
Yes, Your Honor, just briefly. I know all of us here were familiar with Marissa. I'm not as familiar with Marissa as the court is, but while I say I haven't been on the renewal court team long. I've always heard good things about her. Speaking with her today, true. I want to start with the facts that brought us here today and the matter of how it happened. The pill bottle in question. She watches over her nephew, her sister's son. Those pills in question all belong to the nephew. You know, I've conveyed today what could have happened, what should have happened, what we could have done. If it were up to me, and ultimately it's not, it's my client's decision, if it were up to me, I would have ran the prelim, I would have had her sister here testify to that and put it on the matter. She's been in renewal court, she was set to graduate, she hasn't tested positive for anything in over a year. She's on the right track, and in my opinion, she's the best person on the renewal court program, from my opinion at least. I believe the officer in question was fishing. He knows her, every officer here knows every person here. The warrant in question, there was a warrant out from the mistake from the clerks in the juvenile court. They have dealt with that matter. There should have never been a warrant out. They have dealt with that matter. Those pills, they weren't hardcore drug pills. They were pills prescribed to the nephew. Every one of those you can get a prescription from the pharmacy. That's why in my question, I wanted to run the prelim. I wanted to have it on the record. I wanted it to be testified. But Marissa here just wanted to get it done and over with. She wants to continue with her sobriety. She wants to continue in renewal court. She wants to graduate. She has been doing everything she has supposed to. She has been doing very, very good. I think at this time, you know, I commend her and I applaud her for just getting it done and over with. You know, it's sad that we're here today. It's sad that she just got a new charge. I don't think it's rightfully deserved, but ultimately those are the facts. She wasn't partying. She wasn't on hardcore substances. You know, she was just watching her nephew like any other sibling would to do. You know, I don't have any, but if I did, I would watch them. So, you know, at this time, I know I just asked for suspended time for the probation to run concurrent with her current probation. I asked that she continue to be in renewal court. She's been doing a great job. I know she's going to graduate, even though it's not estimated when now, even though it's supposed to be in August. But those were the facts that led up to the circumstances. It was just, it's an unfortunate situation, and Marissa just wanted to get it done and over with today. As mentioned on the record, and I'll say this, I wanted to run it, put it on the record, but you know, she didn't want to do that. She wants to continue in renewal court. She wants to continue sobriety, and she's been doing a great job. She gets drug tested more often than anyone else. She got drug tested this past Sunday. Negative, as always. Been like that for the last year. So this time I just asked that she receive suspended time, and then that the probation just run concurrent with her current probation. That's all I really can add at this time, Your Honor.
Thank you. Ms. Muteroni, is there anything you would like to say before I impose sentence?
No, sir.
Okay. Mr. Lewis.
Thank you, Your Honor. Ms. Muteroni was pulled over on March 22nd. Officers recognized her driving a vehicle and determined through a leads search that she had a warrant for her arrest. They pulled her over. They asked her if she had anything on her person that she shouldn't. She advised them that she had a pill bottle in her bra. One of the officers asked her what was in the pill bottle. She advised the officers that they were Vyvanse, which Ms. Muteroni does have a prescription for. The officers asked her if the bottle had her name on it. She said, I think so. They unhandcuffed her, allowed her to remove the bottle from her bra, and observed that the bottle, the name on the bottle, prescription bottle, was Liam Haley. The bottle contained 2 different kinds of pills, none of which were the medication on the prescription label. 3 of them were determined through drugs.com. They were identified through the numbers on the pills. They have a number on them. The officers go to a site called drugs.com and try to identify the pills. 3 of them were identified as Vyvanse, which Ms. Muteroni does have a prescription for. The other 17 pills were identified through drugs.com as amphetamine, a pill containing 5 milligrams of amphetamine and dextroamphetamine. Same Schedule II substance as methamphetamine, only available by prescription. I want to reiterate again that none of the pills in the bottle were what the prescription label on the bottle said was supposed to be in that bottle. None of them. Ms. Muteroni was arrested on her warrant. The pills were sent off to the drug lab for identification and also to determine the quantity of the amount of drugs that were present. The lab report came back that the pills contained dextroamphetamine and amphetamine, 2.04 grams in total of amphetamine, which is a Schedule II controlled substance. Thank you.
Thank you. Mr. Syed, any response?
Yeah, just a brief rebuttal, if I may please the court. My client doesn't have a prescription for Vyvanse. I've asked her, she does not.
They found an empty Vyvanse bottle in her vehicle.
Right, it could have been an old one, but she does not have a current prescription for it.
Well,
But nonetheless, Your Honor, we're not stipulating to the drugs here. I understand there's a pill bottle, the prescription didn't match the bottles in the pill. As I mentioned previously, she was watching her nephew. Her sister didn't want to give her all those pills in the
Are
same
you saying the nephew had a prescription for amphetamines and dextroamphetamine?
Yes.
Is that what you're saying?
Yes, Your Honor.
Okay, but the pill bottle doesn't say that.
Right. She didn't want to put all those, she just needed a bottle to put those pills in for the time she was watching the review. That's all it was. Yeah, and then she did, after the fact, she went to the police station and she brought in the sheet of the prescriptions to the police station. Of course, it's not stated in the report. But all of it, as I mentioned, we can contest to everything that happened. It's Marissa's doing today that she wanted to get it done and over with, showing her maturity. As mentioned, I would have loved to ran this prelim, but that is what happened. She was just being an aunt, watching her nephew, who was on these prescriptions. The officer from the very beginning was fishing for something, because he knows Marissa. The school, I know all the police officers know everyone here. But she was just being a good aunt. She was being a good sister. That's all it really was.
Okay, so hold on, Mr. Syed, come on. I mean, so you're condoning your client's actions by placing pills, Schedule II narcotics, in a bottle that doesn't contain that prescription?
Your Honor, it was just a bottle used to transport for the nephew.
Why would you need a bottle to transport? Why can't you just use the bottle that the prescription came in?
All the same pills in that bottle. He needed certain kinds of prescriptions.
Why would she mix her prescription with the child's?
There was no prescriptions of hers in that pill.
There was Vyvanse.
Well, I guess you shouldn't have Vyvanse either.
Why was there Vyvanse in the bottle?
It's for the nephew, Your Honor.
Vyvanse is for the nephew as well?
Your Honor, I had.
So the child's got 2 separate prescriptions?
I believe he has I don't know the medical history of the child, but from my indication and my investigation, he has multiple prescriptions.
Well, you were ready to run the hearing today. Don't you know that? Do you know if the child has the 2 separate prescriptions?
He does have multiple prescriptions, Your Honor, yes. But nonetheless, Your Honor, it was a brief rebuttal. As I mentioned, it was Marissa's maturity that we got a resolution today. All I ask is just the time be suspended and the probation one concurrent, and she stay in renewal court. She's still doing a really great job in her sobriety. She has not tested positive for anything in over a year. She's doing really, really good. And it's all from renewal court and this court. Thank you, Your Honor.
Well, I have to say that,
Okay. The what I have doesn't have it. Oh, there we go. It's cooking now.
All right, on the court's own motion, I'll ask the clerk to poll the jury.
Juror number 1, is this your true verdict?
Yes.
Juror number 2, is this your true verdict?
Yes.
Juror number 4, is this your true verdict?
I already gave the verdict.
Juror number 5, is this your true verdict?
Yes.
Juror number 6, is this your true verdict?
Yes.
Juror number 8, is this your true verdict?
Yes.
Juror number 9, is this your true verdict?
Yes.
Juror number 11, is this your true verdict?
Yes.
Juror number 12, is this your true verdict?
Yes.
Juror number 13, is this your true verdict?
Yes.
Juror number 14, is this your true verdict?
Yes.
Juror number 15, is this your true verdict?
Yes.
All right, members of the jury, I'm going to excuse you at this time. I have one more legal issue I need to resolve before you can be released from the admonition. So please just hang tight in the jury room for what's hopefully a few minutes, and then we will let you know if we need your further service.
Oh my God.
So please retire to the jury room, and please, the admonition still applies.
All rise to the jury.
It was guilty, obviously, but they didn't show it. I had a tab up. I went to it immediately. As soon as they turned the sound on, we're already polling the jury.
All right. Please be seated. The jury is no longer present. And aggravation phase, we're prepared to proceed with. I'll ask the defendant. Yesterday, you indicated you didn't want to proceed with that and you would rather admit those aggravators. Is that still your desire?
I will still stipulate, Your Honor, even though I object to having an aggravator phase at all.
Okay, so the state has alleged this is a dangerous
We don't care.
offense. Do you understand? And the state has also alleged that this particular crime that you've been found guilty of involved the use or of an accomplice. Is that the extent of the aggravators that you want to prove up?
To the jury, yes, that's all we were going to ask to do.
All right. So, Ms. Daybell, do you understand you have the right to have a jury decide whether or not those aggravators are proven beyond a reasonable doubt?
I do understand that.
And do you understand that by admitting those aggravators or stipulating to them that you'd be waiving your right to have a jury do that?
Correct.
Has anyone forced you or threatened you in any way to get you to waive that right to have a jury decide those two issues?
No.
Has anyone promised you anything to get you to waive that right to have a jury decide those two factors?
No.
Are you waiving those factors of your own free will?
Yes.
The court finds and do you in fact stipulate that this was a dangerous offense?
I do stipulate to that fact.
And you also stipulate that this particular crime would have involved did involve the use of a presence or use of an accomplice?
I will stipulate to that fact as well.
The court finds those to be knowingly, voluntarily, intelligently entered into stipulation. The court will find that those do exist as a legal determination. I'll order a pre-sentence report be prepared on both cases.
Can I waive a pre-sentence report and try to move up sentencing?
No, we're going to have one prepared. Let me ask the state, as far as the state's presentation and how many people might speak at sentencing, do you have an estimated time?
Your Honor, 1 second. Your Honor, because we are sentencing both cases together at the same time to be safe, if we could block off a couple hours, because there are obviously next of kin and victims from both cases. It
All
may
right.
be less than that, but I think to be safe, if we could do that.
All right, this courtroom is going to be taken over by Judge Myers in a week and a half, but he is out the whole week of July 28. So this courtroom would be vacant. We could use this courtroom.
Okay.
So I can do it pretty much any day that week.
Look, I know this feels illegal, but it's not. It's just something that the insurance companies pray you never find out about. I was paying $2,765 a year for home insurance, and like a sucker, I just kept renewing. Same bill, same company. Then someone told me about this site with no agents and no phone calls. They have a tool that connects you with better insurance options instead.
The way you handled this situation, Ms. Muteroni, in placing a pill bottle with these kinds of drugs in a bottle without the prescription, correct prescription, in your bra, seems kind of odd. And you may have an explanation for it, and your attorney may say, look, she's showing maturity here by entering a plea today. Yet, hear me out, Judge. Here's our defense. If you want to take ownership of this, you wouldn't true ownership of it, you wouldn't be making excuses. You are doing well in renewal court. You have been doing well. And, I think you've got an incredibly bright future ahead of you. You've had to deal with some pretty overwhelming circumstances of late. And I think everybody on the renewal court team is very happy with your progress and how you've been dealing with those circumstances. You're not a new mother, but you have an infant, and things have been going, you've been handling that situation really well. And then this happens. You could have exercised much better judgment. Assuming Mr. Sage is, everything that he says is true, which I'm not taking as true. Assuming everything he said is true, you could have exercised much better judgment. And I'm not sure if you are taking the same position as your attorney, that the police are out to get me attitude. I'm sorry?
What did you say?
I'm hoping, I'm not sure if you're assuming the same attitude as your attorney by saying the police are out to get me. Because that's what I heard from Mr. Syed a couple times when he was making the argument. The police know me, they're out to get me.
I do think I should have made better judgment, but I do think that cop was very, how he did his job that day was uncalled for in some ways. He just told me to get out the car without even telling me what was going on twice, and then told me if I didn't get out the car, he was going to take me out the car. And I said, for what though? I don't understand. And he said I had a warrant out. And that's when I proceeded to tell him I don't understand how I have a warrant out. I just took care of everything. And he had me in handcuffs, and I told him that I did have my medication in my bra. My Suboxone was in my bra too, that he never even cared to take out or have me take out. He just took the pill bottle right from my hands. I said Liam's medication in his bra and my Suboxone. Never said anything about that being my pill bottle or not knowing. I said my Suboxone was in my bra. I said Liam's medication is in my bra.
And it's only because I care. I do that all the time. I put everything in my bra. That I don't want to have missing, stolen, or whatnot. And I guess that is probably not a good thing. I don't know. It's just honestly an old habit. And I will not do that habit anymore. Obviously, it was not a good idea. But no one ever said that medication was mine. I never told him the pill bottle was mine. So I don't know. That was definitely incorrect on what I heard. I told him my Suboxone was in my bra.
The officer had indications that you had a warrant for your arrest.
Yes.
You may have disagreed with that because
Yeah.
you think you had it resolved. The officer had to do what he did, right?
I
Do you not understand that?
I understand it
Do
now.
you, I mean, it was indicated to him that there was a warrant for your arrest. Whether it's mistaken or not, in his system, it showed a warrant for your arrest.
Yes.
And the officer did what he had to do.
Shout out to my Aussie fans.
You may not have
Especially
liked
Scott
the
Watson.
way he handled it,
I don't know
but
if you
he
can hear
had
me.
to take you into custody because there was a warrant.
Yes. Well, he never took, he just, well, I guess that's handcuffing me.
That's taking you into custody, yeah.
Okay. I guess I thought that would be taking me to jail, but, I don't think, my daughter was crying in the back seat and I said, can a family member come pick her up? And his exact words was, CPS is protocol to call. So I mean, there was a couple of things that could have been handled differently in how he treated me. Now, am I saying he's not, he did his job? Yes, he did his job. But I do feel like the other officer there was looking down at him also in how he was acting.
You know, this isn't a status hearing where we freely talk about things. Some of the things you're saying are troubling for me, hearing you say it. Troubling in the sense that when you're in recovery, and one of my huge pet peeves in this society is when people play victim. Constantly. Ms. Muteroni, look at me and stop rolling your eyes.
I'm not rolling my
Yeah, listen to me.
I was not.
Just listen to me.
I hear you.
You're playing victim. You're playing victim.
Oh, we get some screaming.
And until you surrender, if you wanted to come in here and say, look, I made a mistake, I'm pleading guilty, judge, I'm sorry. That's one thing. Instead, oh, I'm playing victim. Okay, I'll plead, but hear me out. Hear me out. I don't want to hear that. Maybe from someone else, but not from you, who's received the benefit over the last year of intensive treatment, a team that has worked like hell for your recovery, that has walked with you hand in hand to ensure that your past history is in the rearview mirror, truly in the rearview mirror, and that your future is one of absolute, total sobriety and recovery. And when I hear this attitude of playing victim, that's looking into your past. That's someone who says, I've been a victim in the past and I'm still a victim. And that's not, in my opinion, an attitude of someone who's truly looking forward in recovery. See where I'm coming from?
Yes, sir.
180 days jail suspended. She's on supervised probation 3 years. She is going to successfully continue her treatment. You're getting at Lark, right?
Yes.
Where else? Who's your mental health agency?
Signature Health.
Signature Health.
Community Counseling.
And Community Counseling Center. You're ordered to successfully continue your treatment at Lark Community Counseling Center, Signature Health. For substance abuse and mental health purposes, you're to comply with any recommended course of treatment and execute any necessary releases for our probation department, which they already have. To monitor, you're ordered not to purchase, possess, or consume any alcoholic beverage or drug of abuse or any suicidal product or going to embargo the establishment for a period of 3 years. This is consecutive to all other sentences. I will impose a fine of $250 plus court costs. The defendant is advised of her right to appeal, of her right to appeal without cost, of her right to have counsel appointed on appeal without cost, of her right to have documents necessary to file an appeal without cost, and of her right to have a notice of appeal timely filed on her behalf. You will be permitted to continue in juvenile court. And you're ordered to successfully continue and comply with all recommended, all conditions in terms of renewal court. Did you get where I'm coming from?
Yes.
Okay. Anything further, Mr. Lewis?
There's a written dismissal here.
Oh, yes, thank you. Thank you very much. Mr. Syed, anything further?
Not at this time, Your Honor, thank you.
Okay, this matter is concluded. Thank you all very much.
All right, none of my stuff is working. Thanks for coming out. I just gotta bail out. I don't even know if you guys can hear me. I don't know. I'll just restart the computer. That was weird. I went to the verdict. They don't turn it on until after. I mean, I know she was guilty. There was zero doubt. I knew she was guilty. I watched portions of the trial. It was an unmitigated ass whooping, start to finish. So that's that. In the event that you can hear me, thank you for coming out. I will see you soon.